Welcome to everybody and to our guest, Marco Ferrazzani. I would like to briefly introduce myself. My name is Cristina Valente. I am the co-leader of Rome Local Group and the Telespazio point of contact as a member of WIA-E Europe. I would like to introduce briefly also Marco Ferrazzani. Marco is the legal counsel and head of legal services department at the European Space Agency. He is providing a full range of legal services to the agency, particularly in matters of both public and private law, working on the legal and the programmatic aspects of space mission, contributing to the development of ESA policy and participating in the high-level negotiation of international agreements. As ESA legal counsel, he is the advisor to the ESA Director General and to the ESA Council for all institutional and legal matters. Besides, he is sitting on a number of boards, including those of the European Center for Space Law at the International Institute of Space Law, as well as being a member of the French Society of International Law. I have the pleasure to work with him during my university period for my thesis on space law for satellite telecommunication. Before to leave the floor to Marco, I would like just to advise, please, that any questions might be asked on the chat. And please take off the video and put it on mute. Okay, please, Marco.
First of all, good afternoon to all of you, and thank you very much, Cristina, for knowing you since long time and having worked with you and others that I see online here. So it's a pleasure to be back with the friends and colleagues of the space world. You asked me to participate. I'm just trying to give you some ideas of my work and my contribution to space and space agreements the last year. So I prepared a presentation with this. I will be very happy to discuss with any questions that will come and you will help me to look at the chat. And I will also give you some reference. Of course, the presentation and the links in presentation are available to all of you and can be distributed. But let's take this as a personal and informal chat with your association. I know that you're going strong and it gives a lot of motivation and inspiration. Inspiration is a word that I will use during my presentation. I will try now to put on the screen and show you my presentation, which is about you can see the legal regime of the new lunar programs. And in that, of course, you heard a lot about recent announcement of lunar programs. I will go through them in terms of current affairs and with the analysis of a lawyer. As you can see from it's here, I start with the idea of what is outer space. And outer space, has been said, is defined by many as a final frontier. And it is more and more true these days. We all look at space with new ambitions. But my argument is that the final frontier for allowing and learning how to work together, for working together. My first point is space is a place for working together. And this has been the fundamental leitmotif, and actually the fundamental reason for the rules of space, what we call in jargon space law. And the basic rules of going to space among us is that space should be used with a sort of sanctuary, preventing it to become an area of conflict of the people on the earth, but also to be a place where benefit can be distributed between spacefaring and non-spacefaring nations, and to stimulate the advancement of exploration and use of space through efficiency of resources, which means combining resources together and cooperate to go to space. These are some fundamental reasons of having going to space and working in space together. And you know, I come from ESA. Most of you already know very well what is ESA, the many programs that we have, and the mechanism that ESA has put up in Europe among member states to work together. Among the member states, you see the flags in this presentation. 22 member states around Europe who have made the story of ESA. And ESA is one of the few space agencies in the world who has a complete range of programs in all areas of space activities. Covering the full spectrum from science to exploration, safety, navigation, launcher, and so on. In ESA, we have more than 80 programs running in parallel for the member states of ESA and also for the European Union. So it's a quite complete range. And today we will, I will speak about what's called international space cooperation. ESA itself is an example of cooperation. Through ESA, many programs are done among European states, but also then ESA cooperates with others around the world. And here, just for example, ESA is the European agent for International Space Station representing Europe. ESA is a partner with NASA, for instance, like things like the Space Telescope Hubble or James Webb. There's a European component that's brought by ESA. ESA has organized launching from European spaceport or non-European rockets like Soyuz. And ESA is planning to put a robot on Mars called ExoMars in 2022. And this will be done in a cooperation with Russia. So just to give you some examples of how we can do external cooperation between Europe and the rest of the other agencies in the world, they all ask to work with ESA, and ESA is representing Europe in this kind of space cooperation. But today we'll speak more explicitly and more particularly of human space exploration. And by that, the most exciting example that you have, there's a long history of space exploration since the 60s, and the most visible, even visible at human eye, example is the has with permanent human habitation on board of the space station by many crew. And this is becoming important in terms of geopolitics. There are changes in this, what we call in jargon geopolitics of exploring outer space, because there are new actors, new entrants. We will mention that. There are new programs and new technology that make it easier to access and a new actor to access more easily in space exploration. There's also a new narrative of the new actors, the private initiatives, the private operators, and the new narrative for making it and more inspirational. I'll give you some examples in a moment. The new pace, because it is clearly increasing a rhythm of new launches, many launches, if you look even the last few years, and also growing interdependence. It looks like many nations want to go to space, even autonomously, but in reality, this produce dependence on each other, which is good news if you look at the first ideas and principles I spoke about sharing the benefits. There are many new ambitions of new nations entering space, like the United Emirates going or China going to Mars or to moon bases. Many new achievements and alliances which are being made right now. So there is a renaissance of interest in exploring outer space with many new arguments, new ambitions, and new actors. So spaceflight is getting more importance, not only for what it is, but also for what it means, what it brings, because it reflects both a geopolitical situation that we have on the Earth, but it reflects also the ambition of becoming strategic. So spaceflight has been important historically in the last 50 or 60 years, and is gaining new importance. And the question is, it's an open question for debate today, is space through space flight gaining the dignity of becoming the so-called ultimate stage or the ultimate goal to demonstrate dominance or predominance, which was the narrative of the 60s in the space race. And this is something interesting to discuss. You remember this word, the first man. It was so important, so inspiring. And the first man was the first man on the moon in the center, but also became the first man on the movie. This is Ryan Gosling. I don't know if you prefer Neil Armstrong or Ryan Gosling, but this is an example of narrative and image about space flight, heroes of space flight, and the narrative that induces in all of us in the ideas, in the imagination of people. But there was not, before the first man, actually, I would like to argue that there was a first woman and a first man in space, both of whom went to space before Armstrong. Here you see the picture of Valentina Tereshkova and Yuri Gagarin being honored by the United Nations Secretary General at that time. It's a picture of the 60s. Also, this one is narrative. Also, this is geopolitical image that was well built and used at that time by the Soviet Russia narrative. This is all equally valid and important. It's a race. Everybody presents its own narrative. We have many other inspiring women in space, and this is the inspiration of today. Here I put just a few examples from the spacewalk of two NASA astronauts, two ladies who were working in space, to the figures that we have as European astronauts. Here you have the picture of Claudia Nuret, to the famous 13 women that in the Mercury program were prepared to go to space along with men, never made it because it was a political decision at the time. I encourage you to have a look at this movie, which is available, about the story called Mercury 13. You certainly have seen, some of you, the famous movie called Hidden Figures, about the women who work in the program for NASA. And then I want to just put a picture of one of my colleagues, a very inspiring woman I work with a lot. And the picture down is from General Counsel of NASA, Sumara, Thompson King, who's my opposite number, is a poor does I take in ESA the job that she does, to work with a competent and innovative woman that comes to at the top of the career. So I can say myself, I've been inspired by each of these pictures, and I wish the new generation are inspired by these kind of pictures, in addition to the first man or the first woman. I'm also want that the new generation of young people are inspired by this kind of pictures. Probably you have seen this. This is our ESA astronaut Samantha Cristoforetti meeting a group of young girls who were visiting the ESA laboratories and telling them, you can see a video on YouTube is available, how it is important for young girls to be inspired by technological jobs and by STEM careers. And by the way, in this even matter with the Barbie doll, the ESA astronaut Samantha Barbie doll was an excuse, an inspiration symbol to explain to young girls they can very well become an astronaut, that they can take technology careers. And as you know, right now ESA has opened a selection for new astronauts to be qualified, very much open to everybody. And we expect application from many young girls to dream and to be inspired by space and come to work in space. And now I will speak how the space station was built, not from a technical point of view, that's a prowess, but from the legal architecture. How did we make it happen together? And even before it was built, we had to invent a system, how to get together the various partners. Through I think that's called an international treaty, which means an agreement between the governments of 15 states to build the International Space Station. It was a very long effort, started more than 20 years ago. Actually, the operation started 20 years ago. The agreement work that we did with the partners started 30 years ago by memorandum of understanding between NASA and each of the cooperating agencies. So ESA, the Canadian, the Japanese, and the Russian Space Agency. Sorry. And this was followed by specific technical agreements at agency level with very detailed. So there's a whole business architecture and legal architecture behind, including simple things such as the crew code of conduct. Actually, how does the crew behave while they worked on board the space station operationally, about the commander and so on. All this is written by lawyers and was written as a preamble to be able to start the manufacturing, the launching, and the operations. And this covers everything: management, coordination, structure during operation now. It's something you do not see directly, but it's something that I'm mentioning now because it is the necessary step before any new space station, any new space base. And that's what we've done for the new lunar programs. And that's why I'm mentioning international partnership and the legal architecture. This is it. It works. It's the most advanced and laboratory and impressive in the world today. And it is really a dynamic and very complex system that worked easy because we very easily and very clearly worked on the arrangement, the conditions, and the operational criteria, even the so-called rules of engagement, how to work on the space station, which we'll have to do. We are doing now for the lunar station and also for the lunar bases. The first thing which you find in the treaty is the definition of being an international space station, being permanently inhabited, civil, for peaceful purpose in accordance with international law. And this was also the basis of what we are preparing for the moon and maybe even beyond the moon. The IGA of the space station itself, as I said, started 30 years ago, was signed in 98 and came into force in 2001. That's the way it was worked. This is the full title, a long title, because it is an agreement within the various governments. And you see Canada, US, ESA, Japan, and Russia. It is quite interesting because every government is representing a state, except for Europe, because in Europe we don't have one state. By the way, we had 11 ESA member states participate, and so the governments collectively together, they decided to name themselves the European partner, and these states designated ESA to be the European partner acting on behalf of the participating member states of ESA, which by the way are 11 and not all the 22, because it was a choice, as you know, in the ESA system. Some member states decided to participate in some programs and not others. This is the flexibility of the ESA. And they together make now what's called today the European Exploration Program in ESA. But now, looking at the moon and discussing with this background, I gave you principles, inspirations, and rules. What do we do with the moon? The picture on the left is going to the moon alone. You see the remainders of a lunar module from the NASA Apollo program. And on the right, you see a picture, which is an imagination, one of a picture of my ESA colleagues about imagining how to build a permanent inhabited modules on the moon, maybe using robots who will help building, and having humans actually on the moon base. So are we going there alone or together? Certainly the experience of ESA being an international cooperation agency and the experience of International Space Station and other stations suggests that we're going to the moon and we have to do it right in the sense of doing well together, as my very first slide was suggesting, being the final front of working together, both on the moon and on other exploration missions. And this is something that we have realized, and I'm going to show you. But this also requires a new legal regime for the moon or not. And to do what? What I copied here is a very short article of the Outer Space Treaty of 1967, which just gives us a principle, a strong principle. Outer space, including the moon, is not subject to any national appropriation, like sovereignty, occupation, or the mean, which means not one nation can appropriate, occupy, or say it is my exclusive place only for me. This is the principle which is accepted by everybody. And it was done in 1967, even before the first man put the American flag on the moon. So it's not because there's an American flag on one side of the moon. And by the way, recently, another recent Chinese flag on the other side of the moon is not because there's a flag that it means national appropriation or national occupation. So the question, we'll go there together for having bases on the moon to live, maybe to have a drink on the moon. So which means both for scientific work or even for entertainment work, for whatever humanity will have, of course, for civil purposes, but together, without the idea to have appropriation or exclusivity on the moon, I would say. Nevertheless, you will hear a lot of narratives and different messages. You have seen maybe these things. This is what is being offered to you on internet. You can find them. I just took some pictures, there are several, many, offering to you property, or even writing for you a lunar deed, where for some amount of money, you can have a certificate or a gift you can offer to a friend for a moon deed and a pledge. Is this property? Some of you may be attracted by what I call a new narrative. This new narrative seems to be contrary to what just I said in the previous slide. Now, to be very clear, the previous slide is accepted by all, and no government will ever accept a private act to sell a piece of the moon or some space, some acres on the moon. So what you see in internet may, I would say, it's part of an illusion, a dream. If you want to accede to the dream and have a certificate, so be it. In the fine print, as a lawyer, I would recommend that you read the fine little print in this certificate that says, I am the company so-and-so, Moon Estate, and I make to you this certificate that if one day I can go to the moon and if I can appropriate, you will have the following acres of number of land. So in itself, it shows that in reality, it's not a real a certificate of property as it's worth on Earth. It's not recognized by states, has no legal value, but nevertheless, you can be buying some dream for yourself. Just to give you an example, is my very little note on the bottom, the samples of the moon soil and rocks that were taken from the Apollo mission back to NASA by US law as considered to be US federal assets, means they belong to the US government, the rocks that came back. It doesn't mean that US owns property on the moon. It means that scientific samples, some kilos that came back, are considered by US law as federal assets because they are part of a scientific establishment and mission. And some of them, you know, distributed in the US, you find them in museums, even some were distributed as a gift to some states around the world. You could even find some secondary so-called market of people wanting to sell them, either true or not, but they still are US federal assets. So I don't recommend you buy them because someday somebody in the US, they can claim them back under US law. Again, there are a lot of narrative around, and these are, I would say, more than legal, these are inspirational ideas and principles. And you should consider them as such, as inspirational, as creating some dreams and inspiration to people. So does it now matter about this problem of having lunar occupation and rules about the moon? Some have put here some association, like this Moon Village Association, who correctly says that it is a problem to be solved, that many countries want to go to the moon and we have to choose the locations. And we need to create confidence among different parties to have what's called peaceful cooperation. To have cooperations for peaceful purposes, we have to need confidence. So we really need some common rules. And there are even groups of the United Nations Corpus meeting who will probably set up a working group on space resources. It is a suggestion for next session. There will be some groups, voluntary groups like Space Generation, who would like to set up an idea of governance. These are all different initiatives. Nothing is formal, nothing is official yet, but there's a lot of talk. Again, there's a lot of inspiration on the narrative. And yes, it does matter because we'll have to find common arrangement under the general principles of freedom of exploration and non-appropriation, we have to find some common grounds to build bases on the moon, how to live and work there, what I call the new roles and engagement. And this all goes back again to the treaty I was mentioned, 1967, which is the central document. You can find easily on internet at the United Nations website. It's open to all, already 111 state parties, which means quite a large acceptance by all. It gives the principles that I mentioned: freedom to explore outer space, so means each state can go and explore without asking permission to others. Cooperation and due regard to interest of the others, so we go thinking about sharing the benefits also for the others. And that each state that goes in space, or even authorized going to space, takes the responsibility also for private activity from its own state. So it means that this also applies to private individuals or companies who go to space. So there is this rule of non-appropriation, freedom, and cooperation. It applies also for those entrepreneurs you hear on internet: I want to go to moon, to Mars, I want to establish there. It applies to all. It also gives a fundamental principle that if you go in space and if you cause damage to others, of course you're responsible. You're liable for what you've been doing. This is a general principle. But these are just some fundamentals. It's important because on the basis of that, we are writing agreements for the moon. And here, I would like just to now move directly in what's called the Moon Agreements and the Artemis Accords. And for that purpose, if you allow, I will try, sorry for the noise on the background, I will try to now put a small video about what we've been announcing on going to the moon, on going forward to the moon. Here it is. On October 2020 this year, ESA has signed an historical agreement in the form of a memorandum of understanding with NASA concerning cooperation on the sustainable conduct of lunar operations, and will also play a major role in NASA's Artemis exploration program. It is a genuine partnership with NASA, committing ESA to a civil-human outpost in lunar vicinity. Every launch of astronauts to the moon on board the new Orion will rely on the European surface module for power, propulsion, oxygen, and water. Europe will provide crew accommodation, telecommunication refueling, and amazing views of the moon. And what is more, European astronauts will fly to the Gateway and to live and work in deep space for the first time. Activities beyond the scope of the Gateway, such as future lunar surface activities, are not addressed in this MOU, and will be subject to future cooperation agreements with international partners, with the expectation to complete a multilateral scheme as for International Space Station, before human mission reaches the lunar surface. So more international agreements are to come. As part of the Artemis exploration program, NASA has also introduced the Artemis Accords as an initiative to establish a common set of principles applicable to the Artemis lunar exploration program. As opposed to the Gateway MOU, which are among exploration ISS partners, these accords do not constitute binding international agreements, but rather political commitments to a practical set of principles, guidelines, and best practices. So I wanted to give you this, sorry. Can you hear me well now again?
Yes, Marco.
Okay. Now, this was just a small teaser. You can find it in the website. Here you have the reference. A video which I made just to start explaining, even to ESA colleagues, the difference between the Moon Agreements and the Artemis Accords, because there is a difference I will explain in a minute. So the first thing is the Lunar Gateway, which is a space station. It's a small space station in orbit around the moon. That's what's called the Lunar Gateway. It will be used as a gateway for crew to get there, and then from there to descend on the surface of the moon and to come back. It was much smaller than ISS and not permanently inhabited. And this is made by the four partners, which are, you can see in the picture, which are the NASA, ESA, JAXA, and Canadian Space Agency, who each is, like the International Space Station, is building a component, coordinating with each other, and then launching and assembling around the moon orbit. It will include the inhabited module made by ESA and Japan and NASA. It will also include a cupola system, probably like we made for the space station. So it's a very exciting project. Of course, you can imagine, based on the experience and the modalities of International Space Station. And that was our starting point. The first point was there, what is the architecture for the gateway? And you see we have to develop a new legal architecture. Do we negotiate a new treaty altogether, like it was the IGA of '98? Or do we build on what we have, which is the present treaty, and write the so-called second-level instrument in law? Now, we took the route to try to analyze what was needed. And of course, in that analysis, we looked at the schedule. The idea was announced by the US to arrive building Lunar Gateway by 2024. So it was a quite tight schedule in terms of organization. The heritage of the International Space Station, the experience of the last 20 years of crews and working together among partners, and the adequacy, is it really well done or not? Our conclusion was that there were practical requirements, political consideration, and international law issues. All this came together to one solution to try to use the Article 14 of the IGA. So in the present Space Station IGA, which speaks of possibility that the space station evolve into the additional capability. Capability means extending it, similar kind of thing elsewhere. And this is, we quite stretch this paragraph by adapting the same articles of the IGA, so also for the Lunar Gateway. Copy reliability, the procedure provided in studies in the MOU, and the possibility to amend the IGA or do separate agreement. It was all planned in Article 14, and they have a consistency between the program of space station and the program of gateway, with the right of consultation among all the partners. And finally, it was only possible if, of course, the parties have agreed. So looking already at the IGA of '98, we find a solution that instead of writing a new agreement, to use Article 14 of what we have. And so that's where we wrote the so-called Lunar Gateway MOU, an MOU about the next phase of human exploration for sustainable exploration and use of the moon. This is the objective. That's what we wrote. This is what you heard in my video. It was negotiated by us. I took some time personally to work on that. And the conclusion was what we brought to approval of ESA Council last June 2020 in a specific decision, a resolution, and the approval of the text of the agreement, which was then signed in October by ESA DG and NASA DG. It entered into force on 27 October. Now it's in force. In the basis of that, on that basis, we undertake the ESA program for the modules you've seen, the three main ESA module. ESA working for Orion service module, the ESPRI, and the International Habitat module. And also NASA so far has signed 3 parallel MOUs about the same between NASA, I said ESA, but also Japan and Canada. So it was that. Again, here you see ESA is representing Europe, while Canada and Japan are represented by the government. So ESA there is acting as a government with the mandate of the resolution I mentioned. So this has been the so-called solution, to make it short, which took a lot of effort in analyzing Article 14 and making parallel provision in the MOU. If you look at it, if you read, actually it follows the same articles and the same provisions of the ISS, because they prove to be both legally and technically valid. Beyond that, also in October, and that's the source of confusion, the United States has proposed something else called the Artemis Accords, which are not themselves binding agreement, but they are principles for cooperation in general on the civil exploration and use of Moon, Mars, comets, and the rest. So it's not just the Moon. Artemis Accords is about all exploration, Moon and beyond. Of course, they apply to the immediate NASA Artemis program. And that's why it gets confused with the Gateway. But they contain political commitments and principles, guidelines and best practices. So it's not about the modules or the Moon base, it's about the method, the commitment, and the principle, which I will show to you in a minute. They were also signed as of October, because the USA proposed them in October, and then 8 other countries mentioned here have signed them, either at the level of government or space agency, depending. Each government had the choice to sign. In Italy, they were signed, for instance, by the government, the Secretary of State. In other countries, were signed by space agency, depending what it is. And you see, there are 3 European members of ESA who signed those, plus important space nations like Japan, Canada, even Ukraine participated. Now, what do they contain? They first of all reaffirm the principles that I mentioned before of the UN Space Treaty of '67. Peaceful exploration, registration of objects. When you send in space, you have to tell others what you're doing. Release of data, assistance in case of emergency. These are all contained in the UN treaties. But also the recognition of the benefit of coordination via multilateral forum. Of space nations going to space together, which is totally done today. For instance, so the UN COPWAS meetings. But there's also a clear mention in the Artemis Accords among those who have signed of the contribution to develop international practices and rules for what? For going to Moon and to Mars. So there is an important recognition that we have to develop international practices and rules, because the Artemis Treaty is good principles, but not enough detailed to actually provide for practices and rules for working in space, working on the Moon, and on exploration. And that's why there are some novel principles. First of all, the idea to use open international standards. So use the standards that we already have. To give you some examples, there are standards developed in the UN family, which many states have already followed and adopted, like space debris mitigation or space registration. And whereas so use what we have, but also develop new standards where necessary. For instance, for interoperability, which means working together. Interoperability among nations means that we know how to work together, some locking mechanism or life support or operational orbit, which we do for space station, for instance, and develop new standards for the Moon, for instance. So this is a very important principle, which is not contained in the Artemis Treaty and is contained in the Artemis Accords. In the Artemis Accords also commit to the protection of sites and artifacts of historical value, both on the Moon and elsewhere. You may know that on the Moon today, there are more than 50 artifacts, human-made, left on the Moon, both by the Soviet and the US program, and recently Chinese. So there are many things, modules and robots and cameras, instruments are on the Moon. The idea is to protect them. And also there's a clear mention of the ability to extract and use resources on Moon and Mars. It is not, and this we can discuss, it is not touching the idea of appropriation of land, is the idea that we could extract and use some resources, probably for on-site utilization, exactly to build Moon base, for the regulator, for the oxygen. And finally, the idea to introduce safety zones, which is a principle taken from human experience on the Earth, especially in international relations, to deconflict areas of the world in case for activities. That's a novel principle which has been introduced there. So I really encourage you to look at the Artemis Accord, to read them, to see this principle, which are written in a quite, say, open-ended, skillful way. So my comments, some avenues. First of all, it's interesting. The Outer Space Treaty parties, so the party to the treaty, 111, are all called to follow up. So it is an open text, the Artemis Accords, open to all the parties, the country to the Aerospace Treaty, but of course, only to governments. The mentioning of space resource makes that US approach on space resources and exploitation resource is no longer only a matter of one nation. It's open to others, and it's open to those who sign to consider that. It's important that we look at the legal effects of these statements on the Artemis Accords by the parties to the treaty, because it would mean also an element of treaty interpretation and build some state practice that is intended to complete or complement in a way over time to complement the Aerospace Treaty principles. There's an interesting statement to align future position in multilateral forums. So the Artemis Accords parties wish to align their future position in the forum about exploration, about all these standards. And I believe that the facts and the acts that will come in the future will have to be watched. They will become more and more legally relevant. So we're in a sort of new stage, exciting new era of facts and acts of space law that will become more and more relevant. It is clearly indicated in the Accords that any state that can become a party to these Accords can just submit the signature to the government of the US. So it's a sort of open-ended text, anybody can sign. And it can be seen in the light of international legal obligations and government position, as I said before. So it's up to each government to make up their mind. They don't have to, it's open, but it has a meaning, of course. 3 ESA member states, as you know, that have signed: Italy, Luxembourg, UK. It was a purely voluntary decision on their side. They did not need to be authorized by anybody else. But ESA itself, sorry, not being party to the Aerospace Treaty, is not a government ESA on its own. ESA is the organization of 22 states. So ESA is not a party to the Aerospace Treaty. So it cannot sign the Accords as such. There were many questions about that. But of course, ESA can contribute to the so-called practice, the space practice of recommendations, best practices, rules, or even what I call rules of surface operations and interoperability, because ESA is an actor of space exploration by space station, by Lunar Gateway. So in a way, we will be becoming an actor of producing the standards. And here I wanted to show this because my point here is that space flight itself, as you can see, is not just a technical challenge. However complex is sending a satellite to human space. Space are very complex, activities are very many and difficult, but they need to, and the Accords show it, to get the actors together, to coordinate, to provide interference, and to have a sustainable operations among the parties. Mind that the objective of the Lunar Gateway is sustainable use of the gateway around the moon for sustainable going forward to the moon in a manner which is not the Apollo era of going there for 2 days and coming back, but trying to build a sustainable life on the moon using also local resources. So this can be reached by very adventurous and complex engineering solution, but also to, of course, law. And I'm trying to make the case demonstration how these principles, accords, or obligation or treaty are, of course, essential for this. There are other exploration initiatives you have heard recently. First of all, the first module of the Chinese space station was launched only last month. Today we have 2 space stations in orbit around the Earth, Tiangong and International Space Station. They are orbiting for the first time. We have 2 stations from the international partner and from China. China also landed a module on Mars this month. It arrived in orbit in February and landed on Mars just a few days ago, which is makes China as the 2nd country to be successful on the landing on Mars. You know, landing on Mars is very, very tricky, very complex. And China made it, even if it's experimental the first time, but they made it. And also another important fact in international relations, Russia and China jointly have issued a formal invitation to other countries and to the international organization to join what they call International Lunar Research Station. It's a joint project, Russia and China, and this was actually announced and with an open invitation. Themselves, they signed a memorandum of understanding in March, China and Russia, for the moon base. And the two agencies, CNSA and Roscosmos, said they want to open international participation for cooperation, science, and technology. These are the usual words of the treaty and the peaceful cooperation for science and technology, but it's happening, it's there. So the moon program in cooperation with Russia and China is launched, it's an open invitation. This announcement was done just last month at the UN COPOS session of the Scientific and Technical Subcommittee. You see, a lot is happening. As I said, the narrative and the actors and the programs are multiplying. They're becoming more, and the pace is multiplying. It's becoming more and more rapid in the last time. So we can expect to see a lot has happened since 1 year. Remember the geopolitical goals I mentioned at the opening, and here they come back in my conclusion. Anyway, the intention of the countries is to prevent outer space from becoming an area of conflict, but remain more an area of international cooperation and friendly relations, with the idea to distribute benefits. And these words is not just me, everybody saying that, including all the space powers that you see in COPOS all the time. The idea is to advance exploration with fundamental principles I mentioned, but to have that for exploration, but also for other areas of law, we need stable space law, both international and national. The space law we had in the last 30, 40 years has already now allowed development of international space telecommunication, space exploration, remote sensing. So there's been already a benefit to have a stable framework of international space law, although at times, of course, as I said, incomplete or to be completed. But we have to admit that space law is not static, it's not the same, it evolves over time, it will evolve. And my argument is that we have to favor what I call incremental innovation on technology, but also on space law, which means allowing progressive development in the innovation with the rhythm which is necessary. So depending on the experience, the technology, but also the law will become incremental, and which means allowing novelty in space laws. National space law exists in many countries in the world. Many of them are new, written in the last 10 or 20 years, but we have to allow new space law for the countries who do not have, or revision of existing space law exactly to cope with so-called incremental innovation. And one of the areas where we will need to work in the next few years is so-called space traffic management, how to use best use space close around the Earth in the orbit, and whether we need a new model of regulation to better use. I'm convinced is a topic of the next years. Within the next 10 years, we have to solve that with a sort of system of regulation. For the development of space, of course, there's some fundamentals that remain. The idea of, as I mentioned, from states to continue to give what's called authorizing and continuous supervision of space activity launched from the countries. Developed the observance of the so-called technical standards and guidelines that we have in many areas, which are already useful and pertinent and relevant. And also mind that through the national authorization supervision, the so-called technical and practical suitability means that the rules have to give some essential rules for authorization, which are technically suitable and practically suitable. So easy rules, technically suitable for the operators for the process of national authorization. And to finish this, this means a lot of sharing of technical experience. So those who know, who have some experience, have to give advice for implementation of norms to the others. Even norms, rules, all non-binding standards and principles. And that's what we do at ESA, and I will explain you in a minute, to get to this. This is the picture of the United Nations COPOS meeting, in where this new regulatory approach are discussed in a preliminary way. They don't write national laws, of course, but they are discussing, they're working groups about legal answers and solutions with a more shared knowledge. That's where all the UN members meet. And for there, we need a lot of knowledge and a lot of good common sense by all sides, which is the climate around there. There's a lot of interdisciplinary knowledge, both scientific and legal. And that's why ESA has put in place a program to provide legal and technical advice to member states of ESA that request in the establishment and implementation of national space law. And we give that through legal and technical advice to each state that request, because of the experience in development of missions, standards, and technical requirements, because of the knowledge of the space sector in each member state. ESA has a knowledge and a survey, and it's called an observatory of the space technology in each of the ESA member states. It's a service we give. We give legal advice also how to write new laws or how to make them revised in increments, and technical assistance. And this is a specific mandate I'm giving the reference here, approved by ESA Council Ministerial, exactly to give a mandate, ESA advice to member states, both technical and legal. And we have been doing that in the last years. I can give you some examples of what ESA has done. It helped advise national laws in this country you see on the left in the last 10 or more years. Right now, there are technical assistance agreements in 3 countries who provide for a so-called national authorization system, but they don't have the technical expertise. So they use ESA teams to have a technical survey and report so that they can nationally give the national license authorizing a space mission. It's done through national laws that provide for that. And we continue to do that now for the 4 countries you see on the right side who are considering to either to modify, Norway to modify the old law they have, or to introduce new national space law. It's a very interesting exercise. We're learning a lot from that. And to conclude, just a couple of words about space law. For those who don't know, maybe interest, of course, we have a European Center for Space Law, which is based in ESA, basically in our office of the legal department, created since many years. And the idea is to promote knowledge and interest in space law. The activity of the center is done by one of my staff. You have the email here, and you can become a member and get in touch with more development of space law. The result is that there are activities, and I'm mentioning here just some activities. So we are participating for competition, a symposium which will happen in June at the Copos about space law for the global commons. What is the meaning of global commons and common good in space? And then there's a summer course on space law. Practitioner forum for the members means for those who really work, for lawyers, attorneys, judge, or business people who exchange information and practical experience about space law. This will be in October, Young Lawyer Symposium, and the summer course. So all these activities are available. I'm giving you information for those of you who might be interested. And I'll stop the presentation. I'll be, of course, happy to have any questions.
Thank you, Marco. Thank you very much. Thank you, because your speech is very interesting, and you have talked about and argued that this is so important and topical. So now we can start with the questions, and the first question is on my behalf. Marco, you are head on the important ESA department, and so I suppose that you work with a lot of women. Could you please illustrate your experience with your women colleagues and tell us if you came across different attitudes?
My first reaction is that even though I do not, in my profession, I was a lawyer before coming to ESA, I never made a personal difference among colleagues in terms of gender. I can tell you that in my team, I can appreciate the difference. There is a difference. And first of all, women are the majority of my staff. But this is not an exception, because in the legal profession from the university, I'm used to that majority, but I can tell the difference in terms of analytical skills and capabilities. is very well developed in many women colleagues I know and I work with. And I can really appreciate, because they help all of us collectively to think deeper and better. And I mean it when I say that. It's been true for a long time. So, and I'm really enjoying all my staff colleagues. I have a great team. They allow us to go very far and to be very, very good in our professional service for ESA. But I have several exceptional women in my team, and I always find them very well prepared, and also quite bold and courageous in inventing new ideas and presenting them. And that's why I admire in them. I would like to see the same kind of courage and stimulus from women engineers. I know they're not enough, and they're not enough valued. And you know, ESA has a specific objective now in Agenda 25 to increase the rate of hiring young women engineers. It's one specific objective. And I'm very pleased to see that as an objective. So we really encourage all capable and competent professionals, and especially women, to apply for ESA positions. There are many opportunities.
Thank you, Marco, for your answer. And I think that this information is really important for the young lady that follow us. And also,
just to complete, you saw that also in my presentation, we have several inspiring examples that we put forward. I gave you some inspiring examples. As I say, we should not only watch the movie The First Man, we should watch the movie about the first women.
Yeah. Thank you. Okay, I start with the question that come from our audience. The first is come from Mark. We will go together, but under which concrete conditions? At least meta law brings borders and the basic rules.
So if I understand why, the idea is we go together under which rules?
Yeah.
And that's the whole point. The principles of such, we go together, the rules are only partially written for the principle I mentioned, which is freedom of exploration, sharing of information, helping each other, assistance in case of emergency. Some fundamental principles exist. We have to write the others. We have to complete them. But with the same spirit of open-ended rules in creating cooperation and exchanging information. So the rules are more for common things than for excluding each other. This is the principles of the rule, but the rules have to be written. And that's my point. We have written rules for the International Space Station. We have written rules for Lunar Gateway, including crew conduct, which are inspired by that. And now we have to write rules about moon surface operations and Mars. Yeah. So it's our generation, you on video, those of you who work in space, and the future generation who have to write rules which are oriented to the idea of sharing benefits and working together. Of course, allowing and stimulating also private initiative for those companies who want to give services. I give you just an example. Around the moon, we will need telecommunication services to serve the gateway and the moon surface operations. Like we have on the Earth, we have satellite to serve the surface of the Earth. We need the same thing around the moon. And that's a great opportunity to develop. And the regime of the moon today allows, and even the Artemis Accords allow for that, stimulate for private initiatives, private company to provide telecommunication services on the moon. There's nothing wrong with that. It doesn't go against the principles at all.
Okay, thank you. I don't know if Mark have some point that to intend to understand. Okay, no. Okay, the next question is from Han Eva. I don't know, maybe Marco, you know, why the ESA did not sign the Artemis Accords?
I mentioned it briefly. ESA is not a party to the Outer Space Treaty because it is not a nation state. And the Artemis Accords have been written for the states of the Outer Space Treaty to sign. And there is a reason. The Artemis Accords are a sort of follow-up or complement to the Outer Space Treaty. That's why I mention it. And they sort of complete some principles or even enlarge some novel principles. So it's really addressed to the parties to the Outer Space Treaty. ESA is not a party, but as I said, so we cannot sign. But as I said, ESA will contribute to the practice. So in the practice, we can contribute a lot to the putting in place of the practice and the regulation that will come out of the Artemis Accords. Again, Artemis Accords are not a regulation, but they will build a climate for creating regulations.
Okay, clear, Marco. Okay, next question from Izel. What role play the developing countries in this legal framework?
Now, in the general space law framework, developing countries are clearly mentioned as those who may not have tools of access to space because they're developing, but they can get also the benefit, which means sharing of scientific data. It is explicit. There's even a General Assembly resolution of the United Nations about sharing benefits with those who cannot access space. And you see it today, every day, with the sharing of, for instance, of data that come from meteorological weather satellites, come on the Earth, and the information is distributed to everybody around the Earth. Data from Earth observation, from scientific research. When ESA went with the probe, you may remember years ago, on the Philae on the comet, the scientific results of the comet were given by ESA to all countries around the world without distinction of development level. The first benefit for the developing country is sharing, getting the sharing of the benefits of the knowledge. That's the first step for any scientific adventure, with the hope and with the idea that developing countries can also participate actively, either through new satellite, and today small satellite give them some access, or even sending some payloads. The United Nations has a program to send small payloads from any country in the world who want to send them in space. The UN office has a very exciting program to offer a flight opportunity, even to small SAT and small universities. So there are a lot of possibilities. Of course, the more limited you are, the fewer possibilities, depending on how much can you do, but there are more and more countries now, they're launching payload satellites and experiences in outer space. And this, the first effect I see is inspiration, motivation of a generation of young engineers and young women in these countries to learn, to study and work in space. I was myself helping the emergence US rocket on a small payload from Paraguay. And Paraguay is a space agency and a space program. And this is a big pride for their country and a whole generation of young students to learn about space.
Okay. Now, the next question, Marco, is from Mira. And I think this is a geopolitical aspect. Do you see a legal problem in the current two-track approach where we have China and Russia, they signed the MOU from one side, and the US and its allies in Artemis from the other? And what will be the role of COPOS here?
Good question. And of course, it is true that there are, now we see two initiatives, maybe there will become three in a few years, who knows. It's not more the fact that there are one or two or three initiatives, it's the fact that there are initiatives. I see it as a positive sign that there are several initiatives to go in space and going to the moon. The important thing is that when we get to exploit space, access and exploit, we have rules that make everyone first of all, in respecting the resource, the moon, not depleting the resource or the historical artifacts. And then there is a way to collaborate, to have common procedures, how to work and operate, exactly to avoid interference. So the most important part is the practical effect. If there's one, two or three programs, one program should not be to the detriment to exclude the other one. That's the first principle. And that's what the COPOS is doing and can do very well. The COPOS can advance on the understanding of having coordination and non-interference. Now, whether there's one, two or three program, that's a geopolitical element. It's not even a space element. It's an element on the Earth of our nation states what is their national policy and how do they team up together. Even before going to space, their motivation, their national motivations around that kind of alliances, of course.
Yes. Okay, now the question is from Luca. For commercial application on the moon surface, can we imagine that it will be something similar to what happens today with the geo in terms of spots reservation?
Now, if I understand right, and if it means by geostationary orbit reservation frequency, I think it's the ITU system of frequency in orbit is a good system of distribution of a scarce natural resource. It worked well for many years. You know, it's a long tradition. It's quite an efficient system. And by the way, it's one example I always give to those who mention space resources. New space resource, now it's a new thing. It's not new. We've been exploiting a scarce space resource like space frequency for many years with a system of distributing it to those who can, those who apply. There's a system of reservation and so on. So I think it's a good model, and it will also be a model for the moon and for Mars. The whole question again is to allow, not limit, allow those who can go there, prevent interference, and allow also others to come in, even if they come later. So never make it exclusive to the first arrival that takes it all, but allow a system that other the late, what I call the late comers, those who come a bit later, can still have a chance to do their activities. But for this, we need an international regime. Like ITU is a regime. It's an organization of states with a treaty. And this is the whole point, whether we will have an international system, organization, or agreement to assign priorities or coordinate positions on the moon, on the Mars. And this is all to make. At the end, I believe we'll have to come to some sort of system there.
Marco, but this kind of concept is linked also to the space traffic management.
I agree with you, yes. Also in space traffic management, which is a scarce resource, we'll have to come to some sort of arrangement of method, how to share the use of some orbits in a way that it does not prevent others, also in a way that does not do damage to others. So also there, we'll have to come to, so far, of launching state, of course, everybody launches. It just has to, of course, to notify, to inform the others through registration, but everybody can launch. We'll come at the point where we will need to have a system where some orbits are very much in demand, and we'll have to come to an understanding how to use them without appropriating or making it exclusive, of course.
Okay. Okay, next question is from Izel. Is the safety zone a violation, I think is not of no appropriation principle?
In my view, it is not touching the appropriation, because the safety zone, at least it is generically described in the Artemis Accords. I invite you to read it. It's the idea to have safety in order not to bother others. In other words, it's for protecting activities in that respect. So it is not an absolute, I'd say, prohibition. It's a way how to use the zone in order to protect some operations. And also it is not permanent all the time, and it's not absolute. There's in space law, there's already an article of the treaty that provides the possibility of so-called inspections. So I mean, others can come, of course, by notification, can ask and come and inspect your lunar base and come to visit you in your lunar base. It's possible already. So there is not an idea that I close the door and nobody can enter. It's not there. There's this idea of exchanging, and you can come home and I'll offer you a coffee.
Okay, Thank you. Okay, now next question is from Angeliki. Sorry if I say not correct pronunciation. Can the extracted space resources be owned or purchased, transfer of ownership without creating an implicit priority or claim over the underlying territory or to associated minerals deposits?
Angeliki, who already puts a very sophisticated question. Actually, it's not one. There are three. In my view, there are three legal questions in this. In my view, the resources. I don't like to use the word own or purchase because it's not the purpose of a resource is to be exploited, like frequency. Before speaking of owning or purchasing, which is a transaction, the question is, why do you extract a resource for a use? So the question is, can we first use the resource? And the answer is yes, as long as the resource is not depleted. Depleted means consumed to the point that you cancel it, you destroy it. So if some resources can be used while not depleting the origin of the resource, yes, to a certain level, I agree, they can be used, but this itself does not mean that you are becoming property of the territory. It's not because you're going with a fish boat, catching a fish in the high seas, that you're becoming owner of the sea. So we have to limit, and the law does it very well. Good laws limit the right to what is strictly necessary and useful for the purpose. The purpose is the use of resource. It's not the property of the land. So don't extend the claim and the legal claim to something you don't strictly need. If you need to catch the fish, you have a right to fish, but you don't need to own the sea to catch the fish.
Okay, clear. Now is from Anna Maria. Space traffic management will be addressed mainly to the LEO orbit. Who will be the entity reference for regulatory legal framework management?
The first question is yes. The first need of space traffic management will be LEO, of course, because the orbit closer and most used today. And that's where there's more traffic, more congestion, and they're more dangerous. So the answer is yes. In my view, we will not have a regime for the all space, possible space, but will be only for some selected most useful orbits.
Okay.
The second one is, I would like to know who would be being fully empowered for to regulate, and there is not one. I think this will be a debate that will open in the UN for the years to come, but at some point we will need to have a reference system, like it was done for civil aviation for the ICAO, for the maritime traffic, for the Antarctica Treaty. Each of those situations, sea, maritime traffic, aviation, airspace, or Antarctica, each of them took years, but in the end we have managed to have some sort of system or even authority to regulate that. I think for space, the debate is very open, but it's a matter of the next 10 years. Within 10 years, both legally and technically, we will have to solve the problem because it's becoming necessary. So we are in the right generation, the people who solve the problems to the past.
Okay, thank you. Okay, now another question is from Angeliki. NASA on December 1st announced the winners of the contracts to collect the lunar soil and transfer the ownership to the USA government, while the samples are still on the lunar surface. They will just send back photos to NASA to prove it. How would you define collected in the context of lunar resource utilization?
Well, I would define it in the US law similarly to what I mentioned about the Apollo samples with USA federal assets. We are still here speaking of a few samples, some grams or kilograms. And here you see that they've been done at the Apollo time for lunar soil sample and scientific purpose. So far, in terms of legal status, That's the kind of status of samples. Of course, NASA made this announcement also to open a principle or debate. So it goes beyond the pure scientific, saying, okay, but as you see, and it's quite interesting, NASA doesn't say you're a US citizens and you are selling anybody else. It says, I will buy it. It will become a US federal asset. The government will buy it. Exactly, not to start a sort of auction system among citizens. It is a NASA initiative to promote that idea. Then when you tell me that you just take a picture and send it back, I don't know if you're really collecting it. You are actually taking a picture. I don't know if you're really collecting and bringing it back for some sort of use. So there's a lot to do in the practicalities. The slide I show about lunar deed, I could speak for an hour because there are many different examples of people trying to sell the moon rocks around, whether they're illicit, illicit. There's a whole debate even among American lawyers whether it is lawful at all, whether it's recognized. All I know that if any of you in the US claim to have a sample of lunar soil, immediately US government will ask you to return back because it's US property. That's for sure. That's what my NASA lawyer colleagues tell me.
Okay, thank you. Okay, we're right to the last question, is from Angelica. How can you apply for a job at ESA engineer? Which is the minimum age to apply for it?
Now, as a job for an ESA position, engineer and others, you have to go into the ESA website careers. There are many job vacancies every week. So I advise, I go there, and there's also a function where you can put your email and you are alerted of any new position that comes up, engineer, scientist, whatever. So I really advise you to go and look for that. And there is no minimum age. The minimum age is the age of your qualification diploma. As soon as you have enough experience, many positions in ESA require, of course, a degree, but also some years of professional practice and experience. For instance, the legal department, we require at least 5 years of legal practice after studies. So there's not a fixed minimum age, but there's a minimum experience required, yes.
Okay, thank you, Marco. I would like just to finish this webinar with this kind of conclusions that we know that the institutional investment in space exploration expected to continue to increase. And overall, about 130 missions are estimated in the next 10 years. And of which about 80 missions dedicated to the lunar exploration. What I would like to underline that I agree, as you said before during your presentation, that the legal aspect could have an important impact on the future of this project and the mission, especially because everything starts from legal architecture. That is, I think, that is the great message that we need to understand, that the contest is start from the legal architecture. That is what I would like to underline. And so to say thank you. And I think that we don't have any, because the time is running and we are over the time, but it's okay for us. And I would like to say many thanks to Marco and also to the audience for your active attendance. That is really important for us to share this argue with you, and also to understand, because I think that the next 10 years, our goal is on exploration. The first step is the moon, but the second step is Mars.
Absolutely, Cristina. You said it well, and I thank you for having invited me, giving the chance to discuss with you. We are living in interesting times. Our generation has a chance to do a great advancement in science, technology, and space, and also to prepare even a better generation to do more in the decades to come. So it's a really inspiring. You have been giving inspiring words, and I thank you for that. It's a daily job at ESA and all my colleagues to do that with all kind of audience, especially professional one like you are. And I feel always a duty to inspire a new generation and inspire many women to come to space.
Yeah, yeah. Yes, no, and also because I think that the Italian role in this context, especially at the industrial level, we can have a really good good role in this field. Because,
but you have a great potential of your members. So I wish you good work on that. And if there's ever a need to call on me, I'm ready to contribute in the future. Okay,
thank you very much, Marco, and thank you to the audience. And okay, we are finished. Thank you to everybody.
Very much.
Have a good evening.